Good day, future lawyers. Welcome back and thank you so much for the support. This is part 2 of Criminal Law Review. Let's start. Estafa and Pt.2. The accused can be liable for estafa and also for violation of BP bilang 22, while the two criminal actions of estafa under Article 315, Paragraph 2D of the Revised Penal Code and the violation of Batas Pambansa bilang 22 may refer to identical acts committed by the accused. The prosecution thereof cannot be limited to one offense because a single criminal act may give rise to a multiplicity of offenses, and where there is variance or differences between the elements of an offense in one law and another law, there will be no double jeopardy, because what the rule on double jeopardy prohibits refers to identity of elements in the two offenses. Otherwise stated, prosecution for the same act is not prohibited. What is forbidden is prosecution for the same offense. Essentially, while a BP22 case and an estafa case may be rooted from an identical set of facts, they nevertheless present different causes of action, which under the law are considered separate, distinct, and independent from each other. Both cases, therefore, can proceed to their final adjudication, both as to their criminal and civil aspects. Diversion as defined under Republic Act No. 9344. Diversion refers to an alternative child-appropriate process of determining the responsibility and treatment of a child in conflict with the law on the basis of his or her social, cultural, economic, psychological, or educational background without resorting to formal court proceedings. Diversion program refers to the program that the child in conflict with the law is required to undergo after he or she is found responsible for an offense without resorting to formal court proceedings. Community-based programs refers to those programs provided in a community setting developed for purposes of intervention and diversion, as well as rehabilitation of the child in conflict with the law for reintegration into his or her family and/or community. Intervention refers to a series of activities which are designed to address issues that caused the child to commit an offense. It may take in the form of an individualized treatment program, which may include counseling, skills training, education, and other activities that will enhance his or her psychological, emotional, and psychosocial well-being. Juvenile justice and welfare system refers to a system dealing with children at risk and children in conflict with the law, which provides child-appropriate proceedings, including programs and services for prevention, diversion, rehabilitation, reintegration, and aftercare to ensure their normal growth and development. Restorative justice refers to a principle which requires a process of resolving conflicts with the maximum involvement of the victim, the offender, and the community. It seeks to obtain reparation for the victim, reconciliation of the offender and the offended and the community, and reassurance to the offender that he or she can be reintegrated into society. It also enhances public safety by activating the offender, the victim, and the community in prevention strategies. Libel. Fair comment on the acts of public officers related to the discharge of their duties is a qualified privilege, hence, the accused can still be held liable for libel if actual malice is shown. In fair comment, actual malice can be established by showing that comment was made with knowledge that it was false or with reckless disregard of whether it was false or not. Journalists bear the burden of writing responsibly when practicing their profession, even when writing about public figures or matters of public interest. The report made describing a lawyer in the Bureau of Customs as corrupt cannot be considered as fair and true since he did not do research without making his allegations, and it has been shown that these allegations were baseless. The articles are not fair and true reports but merely wild accusations. He has written and published the subject articles with reckless disregard of whether the same was false or not. Next, economic abuse defined under Republic Act 9262. Economic abuse refers to acts that make or attempt to make a woman financially dependent, which includes but is not limited to the following: 1. Withdrawal of financial support or preventing the victim from engaging in any legitimate profession, occupation, business, or activity, except in cases wherein the other spouse or partner objects on valid, serious, and moral grounds as defined in Article 73 of the Family Code. Number 2, deprivation or threat of deprivation of financial resources and the right to use and enjoyment of the conjugal community or property owned in common. Number 3, destroying household property. And number 4, controlling the victim's own money or properties or solely controlling the conjugal money or properties. Next, defense in the crime of fencing. Fencing is the act of any person who, with intent to gain for himself or for another, shall buy, receive, possess, keep, acquire, conceal, sell, or dispose of, or shall buy and sell, or in any other manner deal in any article, item, object, or anything of value which he knows or should be known to him to have been derived from proceeds of the crime of robbery or theft. While under Section 2, Pt. 1612, mere possession of any good, article, item, object, or anything of value which has been subject of robbery or thievery shall be prima facie evidence of fencing. Such evidence, when sufficiently overturned, constitutes a defense. In the crime of fencing, such presumption is overcome by presentation of receipts showing that her transaction is legitimate. Absent other evidence, the presumption of innocence remains. Republic Act 10640, amending Republic Act number 9165. Under varied field conditions, strict compliance with the requirements of Section 21, Article 2 of Republic Act number 9165 may not always be possible. The implementing rules and regulations of RA 9165, which is now crystallized into statutory law with the passage of RA number 10640, provides that the said inventory and photography may be conducted at the nearest police station or office of the apprehending team in instances of warrantless seizure, and that non-compliance with the requirements of Section 21 Article 2 of Republic Act number 9165, under justifiable grounds, will not render void and invalid the seizure and custody over the seized items, so long as the integrity and evidentiary value of the seized items are properly preserved by the apprehending officer or team. The failure of the apprehending team to comply strictly with the procedure laid out in Section 21, Article 2 of Republic Act number 9165 and its implementing rules and regulations does not ipso facto render the seizure and custody over the items as void and invalid, provided that the prosecution satisfactorily proves that A, there is justifiable ground for the noncompliance, and B, the integrity and evidentiary value of the seized items are properly preserved. Pursuant to Article 336 of the Revised Penal Code, acts of lasciviousness is consummated when the following essential elements are present. A. The offender commits any act of lasciviousness or lewdness upon another person of either sex, and B. The act of lasciviousness or lewdness is committed either by using force or intimidation, or when the offended party is deprived of reason or is otherwise unconscious, or when the offended party is under 12 years of age. As thus used, lewd is defined as obscene, lustful, indecent, lecherous. It signifies that form of immorality that has relation to moral impunity, or that which is carried on a wanton manner. However, in a 2019 case, People versus Tulagan, the Supreme Court held that upon the effectivity of Republic Act number 8353, specific forms of acts of lasciviousness were no longer punished under the said article, but were transferred as a separate crime of sexual assault under paragraph 2, Article 266-A of the Revised Penal Code, committed by inserting penis into another person's mouth or anal orifice, or any instrument or object into the genital or anal orifice of another person against the victim's will. Sexual assault has also been called gender-free rape or object rape. Considering the development of the crime of sexual assault from a mere crime against chastity in the form of acts of lasciviousness to a crime against persons akin to rape, as well as the relevant rulings in the cases of Dimakuta and Kawili, the Supreme Court likewise held that if the acts constituting sexual assault are committed against a victim under 12 years of age or is demented, the nomenclature of the offense should now be sexual assault under paragraph 2, Article 266A of the Revised Penal Code in relation to Section 5B of Republic Act number 7610, and no longer acts of lasciviousness under Article 336 of the Revised Penal Code in relation to Section 5B of Republic Act number 7610, because sexual assault as a form of acts of lasciviousness is no longer covered by Article 336 but by Article 266A, paragraph 2 of the Revised Penal Code as amended by Republic Act number 8353. Nevertheless, the imposable penalty is still reclusión temporal in its medium period and not prisión mayor. Proximate cause. Even if the victim is suffering from an internal ailment, liver or heart disease or tuberculosis, if the blood delivered by the accused, A, is the efficient cause of the death, or B, accelerated his death, or C is the proximate cause of death, then there is criminal liability. Apropos,
To all this is that time-respected doctrine, he who is the cause of the cause is the cause of the evil caused. This is the rationale in Article 4 of the Revised Penal Code, which provides that criminal liability shall be incurred by a person committing a felony, delito, although the wrongful act done be different from that which he intended. Bigamy is punished under Article 349 of the Revised Penal Code. The penalty of prisión mayor shall be imposed upon any person who shall contract a second or subsequent marriage before the former marriage has been legally dissolved or before the absent spouse has been declared presumptively dead by means of a judgment rendered in the proper proceedings. For an accused to be convicted of this crime, the prosecution must prove all of the following elements. First, that the offender has been legally married. Second, that the first marriage has not been legally dissolved, or, in case his or her spouse is absent, the absent spouse could not yet be presumed dead according to the Civil Code. Third, that he contracts a second or subsequent marriage. And lastly, that the second or subsequent marriage has all the essential requisites for validity.
And we're done with part 2, and there's going to be part 3, so stay tuned and thank you so much for watching.